Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, the purveyor of the Slow Facts blog, also the guy behind the self-defense gun stories, now in the top 1% globally of all podcasts, Rob Morse. Rob, congratulations on joining the very rarefied air at the top with the self-defense gun stories, man.
What Paul is mentioning is a story by John Petrolino, who looked at a number of Second Amendment podcasts as ranked by listen notes. Yes, I'm in the top 1%. There's obviously a glitch in the algorithm.
No, there's no glitch there, man. And I'm going to give an open, bald-faced plug for my friend. Rob says it all the time, but Self-Defense Gun Stories is a very easy listen for podcast listeners. It's a short little 20-minute podcast once a week. You get a little amount of time, but you get a lot out of it. So and let me get CNT Designs and Arms. By the way, if you're watching on YouTube or Polite Society Podcast Facebook channels, you can comment. We'll get your comments right away. We'll get them on the air. But this one from Coop over at CNT Designs and Arms says, I listen to Self-Defense Gun Stories today. So
thanks, Coop.
There you go. Rob, we do have a lot of stuff we need to talk about today. First of all, yesterday there was a ruling from the Supreme Court, not necessarily going the way we wanted it to go. We've got a press release from SAF. You want to tackle that one to start with?
Yeah, I will. And as Paul mentioned, this came out on Tuesday. The U.S. Supreme Court granted a stay. The stay was sought by the Biden administration. This was a ruling in a federal challenge to the BATFE's new rule on frames and receivers. Their rule on frames and receivers said homemade gun parts are, in fact, guns even when they're gun parts still. U.S. Supreme Court's decision allowed the ATF rule to remain in effect as the case moves through the U.S. Fifth Circuit Court of Appeals. The reason this is interesting is the Fifth Circuit said, yeah, we've looked at the merits. We think the government will fail. And they put in a stay, meaning the ATF's rules would have been held in abeyance. SAF was allowed to intervene on the case. The case, called Vanderstock versus Garland, includes a petition for the case to be moved from the Fifth Circuit and to be heard directly by the U.S. Supreme Court. If that petition is made and denied, then the state terminates. If certiorari is granted, meaning it's accepted by the Supreme Court, then this stay put in by the Supreme Court remains in effect pending the final distribution of the Supreme Court's ruling. Adam Kraut is speaking for the Second Amendment Foundation, and he said, while we're disappointed that the government's final rule remains in effect, we remain optimistic that we will ultimately prevail. We believe the district court's rationale, which struck down the final rule, was legally sound. We look forward to defending our position on appeal. SAF's founder and executive vice president Alan Gottlieb added, the U.S. Supreme Court, in issue its ruling, did not address the merits of the case. They only said that the stay will remain in effect pending the appeal now before the Fifth Circuit. The disposition of the writ of certiorari, if such a writ is timely sought. Now that the Fifth Circuit can actually rule on the merits of the case, we expect a very favorable ruling, close quote. Oral arguments in the case are scheduled for September 7th. Kraut added that sort of schedule says this case is moving quickly.
Yep.
Paul,
yep.
What would you add?
I'm going to say that, well, let me get a comment from Warsaw Patriot. He says, the pistol brace rule, I think we're going to win. The frame and receiver rule is going to be more difficult to fight and win. I think we're going to win both. I really do. And let me get another comment in here from CNT Designs and Arms. Coop says, Robert's vote was not a surprise, but Amy Coney Barrett's vote was. Rob, you and I talked about this as we were getting ready for the show. Roberts, I'm not going to call him a rhino, but if it walks like a duck, quacks like a duck, and waddles like a duck, the Amy Coney Barrett, that vote, I would have expected to go the other way, and it to have been a 5-4 the correct way. Again, but as a lot of.
But again, this is not on the merits of the case.
Yeah.
This is on, if you will, deference about should a rule from the government remain in effect. Well, actually, it's not from the government. It's from a government agency. It is, the argument here is this supported by the fundamental legislation? That's what will be decided in the case. And Barrett seems to believe that, barring phenomenal evidence from a lower court, that the ruling by the government agency would stay in effect until the case is decided.
And I mentioned, I believe it was when we were on Polite Society podcast on Monday. Here's one thing where this is comforting in a way, because it's saying, look, if anybody's going to give a nationwide injunction, we want it to be the Supreme Court. We don't want liberal justices who are at the very bottom tier of federal judges giving nationwide injunctions.
Ruling.
Because, yeah.
But didn't we have judges from Hawaii saying that their decision on imposition of COVID regulations was binding on the nation? Yeah.
We did. And
so there's some selective enforcement, selective interpretation here.
Could very, very well be. There's an interesting one. Let me get this one up. Coop again. Could this vote by Amy Coney Barrett in some way speed up or reinforce SCOTUS taking this case?
It beat that above my pay grade, but that's a fascinating question.
Yes. All right, let's see here. And I want to get up. We had Warsaw Patriot. Let me just say, Warsaw Patriot, I'm going to answer you in comments as the show goes dark. No, I did not get, my email is wonky right now. I'm going to give you another email address to send to. But hang on, I'll get that in the comments actually, probably later in the show. But I do want to move on to our next story. This, as well as the Second Amendment Foundation press release. The Second Amendment Foundation today filed a motion for the U.S. District Court for summary judgment in its challenge of Washington State's ban on so-called large-capacity magazines in a case known as Sullivan versus Ferguson. SAF is joined in this case by the Firearms Policy Coalition, Rainier Arms, and a private citizen, Gabriella Sullivan. We maintain this magazine ban is unconstitutional, said SAF founder and executive vice president Alan Gottlieb. As we note in our motion, magazines capable of holding more than 10 rounds are in common use across the country. There are millions of such magazines, including huge numbers in Washington, and modern rifles and pistols come from the factory with magazines that hold more than 10 cartridges. This is a quote from Adam Kraut, who's our executive director. Designating 10 rounds was an arbitrary number for which there is no justification. Anti-gun lawmakers and Governor Jay Inslee seem to settle on that number as some sort of magic limit. There's no basis in this nation's history or tradition to restrict firearm magazine capacities to such an illogical number. As SAF notes in its motion, the magazine ban is a complete prohibition on the commerce in ammunition magazines holding more than 10 rounds. The Supreme Court has 3 times answered the specific question of what historical traditions of firearms regulation can possibly support modern day bans on certain types of firearms. Those cases establish that states can only ban arms that are dangerous and unusual. Many magazines holding more than 10 rounds or magazines holding more than 10 rounds are neither. One last quote from Alan Gottlieb: courts and legislatures do not have the authority, nor can they be allowed to second guess choices made by law abiding citizens by questioning whether they really need firearms and the cartridge magazines designed to be used in those firearms. Rob, this I don't expect them to get the summary judgment. They filed for it, but what's your thought here?
Well, okay, here's Second Amendment law is pretty clear. This is a gun ban case. Go back to Heller. That was a gun ban case. Being in common use, and magazines clearly are, imposes a burden on the government. The government has to show that there's long-standing regulation of this type when the Second Amendment was written. Now, by the way, to show that this isn't that this is very clearly a political argument on the part of gun prohibitionists. Today I read a gun control advocate's proposal that, yeah, anything with more than 5 rounds is an assault weapon. I hear that right after they get that, they'll be asking for 3.
Yeah, that means that your classic 6-shot wheel gun is now an assault weapon.
Yeah. You've read the playbook, partner. That's how it goes.
Yeah. And then next thing is anything over 3 rounds, because 3 rounds is what you're allowed in. And where they're going to come up with that number is because that's what you're allowed in hunting when you're hunting waterfowl. That's where they're going to come up with 3. So, yeah.
And by the way, that came from the desire to limit the rate at which wild animals were being taken to make sure that some survive for reproduction the next year. Mm-hmm. I get it.
Yeah.
By the way, Paul, that, of course, would never apply to government employees or the people guarding our politicians, would it?
No, not at all.
Right.
There are some extreme left-wing liberals that do want to disarm the police to a large degree, but not they will always carve out exceptions for their personal security.
Shall we talk about New York next?
Hold on just a second. Let me get some comments in here.
Sounds like a plan.
Let's get...
will you flip me when you get a minute?
Oh, yes, sir, I will. There we go. Warsaw Patriot says, Paul, by the way, the Republican legislators suggested a bill that would require politicians and legislators to take a gun course and more. As well also be educated in what they're actually regulating. Rob, that's all you have to be, and everybody watch Rob closely. Bing.
There we go.
All you have to be a legislator is being good at getting elected. That's all the knowledge you have to have. And then for the rest of it, you rely on your staff, and your staff is as good or as bad as you want them to be.
This particular bill, put forth in Illinois, it was not brought out of committee, required that if legislators were going to make Second Amendment laws, they had to pass at least a range safety officer course. I don't even think shooting is required in an RSO course.
Nope. Having taken an RSO course, I can confirm that no shooting is required in an RSO course. Let's see here. CNT, let me get another comment in by Coop here. The government will lie because there is no historical backing for gun laws. You're absolutely right there.
What I find absolutely embarrassing, Coop, is that they will use Jim Crow laws that were designed to disarm disenfranchised blacks and say, see, we did this before. What could possibly be wrong with that? And it makes me just think, have you no shame? And the answer, as you point out, is no, they don't.
No, not. Well, this has been several years ago, but I want to go back to the California legislator that when showing a picture of a firearm said, "Isn't that the shoulder thing that goes up?"
Goes up. I thought you were going to talk about Leland Yee.
Oh, yeah.
Was given,
that actually
awards,
dovetails into our next story. That does dovetail wonderfully. And I was reading on Slowfax today, and let me actually, the headline for the story is Gun Violence Prevention Activist Accused of Orchestrating Major Guns and Drug Ring in New York City. Rob, that's off your blog, man. Can you fill us in a little bit?
Right. The Law Enforcement Task Force and efforts to get this guy, and in fact get the entire gang, what was it, a dozen people, was called Operation Hiding in Plain Sight. This was a gun violence prevention activist. He's accused of orchestrating a major guns and drug ring in New York City. He's doing this just days after going on the news and praising his organization for bringing peace to my community by controlling guns while he's selling them to the thugs. His name's Michael Rodriguez. He was arrested after being snared in a 2-year-long investigation. He's 49 years old. He's arrested in his home in Yonkers, New York. That happened on July 26th. Cops seized a cache of illegal contraband, including over 1 kilo of cocaine, 3 pistols, and a shotgun. He's found with $165,000 in cash, $50,000 in jewelry, and is accused of orchestrating trafficking ring while being an executive director of, quote, the Bronx Rises Against Gun Violence. Do you want to bet there's a Bloomberg hook in there somewhere, Paul?
Oh, I would not doubt that in the least. And one of the things that I haven't brought it up recently, but I have brought up in the past, is transference. If I had a gun, I would do this, so you should not be able to have a gun. This is the absolute epitome of that. Because this guy is trafficking drugs, because this guy is trafficking guns, this is more than transference. This is anti-competition. This is I want to corner the market here.
Yeah. Exactly what it is.
And
but remember, the old Sullivan Law in New York was a way for a legislator to say, look, the new immigrants, I want my criminal gangs to make sure that the new immigrants, I think in that case they were Italian, were disarmed. Well, the Irish were armed because they've been here a while. By the way, I have that backwards. I'll let you New Yorkers fix me on that. What you were starting to mention was we've seen a similar activity in a California state senator, Leland Yee, who was given awards by Bloomberg's Moms Demand Action, saying the gun control bills you propose are so great, while he's funneling firearms to, were they Philippine mercenaries?
Yeah, Filipino gangs, yes. And by the way, we're not just talking run-of-the-mill Glocks. We're talking firearms with fun switches and also rocket-propelled grenades.
RPGs. They look like bazookas.
Yes.
And if that doesn't get any comments, then we'll go to Hawaii.
Well, yeah, but and we're going to be going to Hawaii here very shortly anyway because we're getting down towards where our time is. But I believe Yee is still, isn't he still? No, he got out of prison,
He got out.
and I think he wants to run for California
Yes,
legislature again.
right. And I'm
Uh,
sure a bunch of Democrats would vote for him.
oh yeah, well, and the guy is a convicted felon and has spent. Let me actually see how fast my Google foo is working.
Okay, then I'll tell you what. Let me talk about Hawaii.
Yeah, to go ahead and take that.
Okay, the good news is Hawaii cannot ban guns on beaches. A federal judge blocked the state of Hawaii from enforcing a recently enacted ban on firearms. This was their anti-Bruin spasm passed by the Hawaiian legislature. Guns were banned on beaches, banks, bars, parks. U.S. District Judge Leslie Kobayashi in Honolulu on Tuesday, yesterday, concluded that the prohibitions likely infringed on the right of permit carrying gun owners to carry firearms in public, and that's a right granted by the U.S. Constitution in the Second Amendment. Those restrictions were enacted after the conservative majority Supreme Court in June 2022 declared for the first time that the Second Amendment's guarantee of a person's right to keep and bear arms protects an individual's right to carry a handgun in public for self-defense. The judge's decision, the U.S. Supreme Court's decision, New York State Rifle and Pistol Association v. Bruin, announced a new test for assessing firearms laws. The restrictions must be, quote, consistent with this nation's historical tradition of firearms regulation. The judge's ruling in Hawaii prompted the court's ruling prompted Hawaii lawmakers to pass a bill that Democrat Governor Josh Green signed into law that June, and that sought to comply with the decision while deterring, quote, gun violence by barring firearms in, again, quote, sensitive places. As you can imagine, the measure was challenged by 3 Hawaii residents and the gun rights group Hawaii Firearms Coalition. They said that the prohibitions imposed by the state were unconstitutional. Hawaii Attorney General Ann Lopez argued that the law was consistent with historical gun regulations, and it served, quote, a state interest in protecting public safety. Well, you know what? That's an interesting balancing test. No, not interesting. That's an interest balancing test, and that's been found to be unconstitutional. While Kobayashi acknowledged the important role beaches play in Hawaii's economy, the state does not provide any evidence that this nation had a historical tradition of regulating or prohibiting the carry of firearms on beaches. What's more interesting is that Kobayashi, an appointee of Democrat President Barack Obama, said Hawaii's ban on guns in bars and restaurants likewise failed due to confounding and curious way the U.S. Supreme Court defined what constitutes a historical tradition of gun regulation. Alan Beck, an acquaintance of ours, was the lawyer for the plaintiffs. He hailed the judge's temporary restraining order, saying Kobayashi faithfully applied the Supreme Court precedent and came to the correct result. A spokesman for Attorney General Lopez did not respond when there was a request for comment. Paul, what do you think? Paul, you're muted.
I am no longer muted, I hope. Hawaii is a chain of islands. There are a few very busy public beaches there. There are a lot of very wild beaches where there are very few people and help is a long way away. This is, even from Hawaii's rationale, the Attorney General, this is the correct decision simply because I would say probably the majority of beaches on Hawaii, there are not lifeguards right there. There's certainly not law enforcement right there. And if you need to defend yourself, you need to you have they do not should not have that right to take that. They should not be able to take that right away from you. Eventually, I'm going to learn how to talk. Finally, with proper training, I don't care how crowded the beach, with proper training, you can minimize risk to other people while using your firearm to defend yourself. Because I can get to a point where I can make sure that any shot I take does not endanger any people other than the bad actor. So
This is the argument about Times Square all over again.
yeah, it is.
And the U.S. Supreme Court said, look, just because police are there doesn't mean that people have to give up their right to keep and bear arms. Given that many places in Times Square, the police are still 15 minutes away. They're certainly not going to be there to protect you. As we found out in a recent ruling, even officers who are tasked with protecting sensitive areas, schools, beaches, playgrounds, they're under no legal right to move toward any violence. None.
Yeah, there's no legal precedent for them saying, because you are law enforcement, you must run toward the sound of the guns.
Right.
There's been multiple cases that say, look, just because it says protect and serve, it doesn't say to protect and serve who.
Right.
So let me get to a couple comments. This one is interesting from Coop. When NFA was passed, the only people left that could afford machine guns were the gangsters. And I don't know that they could anyway.
Coop, okay, let's put this in perspective. Do you recall that the Remington 870 was called that because it had $8.70 worth of parts to make it when it was first invented? The $200 tax step was the equivalent of about $4,000 today.
Yes.
Which describes how our money's been eroded. So it's not like automatic weapons are difficult to make. You're bending up a piece of sheet metal to form an auto sear. Believe me, if you can move millions of dollars worth of booze around, you can get somebody to bend up an auto sear for you. It's not like they went out and bought legal automatic weapons.
No, they didn't. And I'm going to say this right now. If the NFA were to go away today, the vast majority of full autos would be in the hands of people like Rob Morse, people like me, people like Coop Cooper, people, just normal everyday people. Would criminals get some? Yes. Would they be used in crimes? Yes. Would they be used to defend against crimes? Oh, heck yes.
Maybe I'm not that smart. We do read about criminals who put an auto sear in a Glock, and you run out of ammunition in a fraction of a second.
You do.
And a lot of those bullets marry with the sky. So I'm not sure I'd have a fun switch. I'd have to learn more.
The day they become legal, I'm going to, and you don't have to go mother may I to the government, I'm going to get one. I am going to get one. Will I use it on a regular basis? I'm not a rich man, so probably not. I didn't win the Mega Millions Power Super Lottery last night. So, no, I probably won't use one. I will probably get one or two, one handgun, one rifle, maybe a 20 gauge shotgun. I'll get maybe three, or now that I think, anyway, I'm going to get one. When the NFA goes away. I just don't know that I will change what I carry on a regular basis.
Oh, I did hear something. You know those short shells used in shotguns?
Yeah.
I heard of those called hater tots. That was
All
Paul
right.
Markle. I love that.
Um, Let me get two more
Yeah, we're
comments
there.
in here. Yeah, and then we got to get out of here. The $200 tax stamp was the cost of a machine gun from a dealer, and there was no prohibition on felons owning guns at the time.
There you
And
go.
Jesus Wins slash Bird of Michigan, who's had several comments. This is the first one that gets up there. Miss my AK-47. So simple, so beautiful.
There you
All
go.
right. Well, Rob, we are at that time, man. We're actually a little over the 30 minutes. So if I could, we talked a lot about your self-defense gun stories already, but plug it again and anything else you want to plug today, man.
Okay, I host the Self Defense Gun Stories podcast. Comes out once a week. Not like Paul, he comes out every day. Mine's only 20 minutes. It's a little snack food of a podcast. Slip it in your pocket. I want you to do that because I'm tied for third place with a number of other podcasts. I want you to put me over the top. I'm also a co-host on the Second Amendment Foundation's Polite Society podcast. I write the Slow Facts blog, 2,100 articles there. My writing is picked up at Clash Daily and sometimes at OpsLines. Paul, it's been a pleasure.
Oh, it's been a blast, man. I love working with you, Rob. Rob,
Thank you.
by the way, for people who have followed what I do for a long time, know that Rob was one of the first people to come on, besides me, onto what was then the Politics and Guns podcast. Uh, Anybody I currently work with, Rob, I've worked with the longest. And I hope that working relationship extends. We've been working together, what, 10 years, Rob?
About, yeah, has to be.
Yeah, I'm hoping for another 10 to 20 in the future because Rob is an absolute genius when it comes to this stuff. And I try to keep people that are smarter than me around me. So hopefully some of that rubs off. It just hasn't yet. All
Thank you,
right.
sir.
Everybody, that is it. We're going to shut down for today. Please do come join me tomorrow, Thursday. I will be solo tomorrow, I think. We'll talk about the news of the day. And then Friday is our Legal Friday. It was going to be with Alex Uli. Alex is going to be on vacation for the next 2 weeks. So we're going to find somebody to talk legal. We'll get more into the SCOTUS case, the SCOTUS decision on Friday. And Saturday, let me get this one up here real fast. Saturday is, of course, the Week in Review show. And one of the people on that Week in Review show is Brooke Cheney from A Great Start Shooting School. And she says, I love snack food podcasts. And she says, see you on Saturday. So thanks again, everybody. That does it for today. Until next time, we'll see you. And we will see you next time. Thanks, everybody.